and thank you for being here again. People are still coming in, but we'll go ahead and get started. If you, I think you said you were going to present a screen with us.
Yes, I'm going to share my screen.
Perfect. Okay. So you can go ahead and do that, and we'll go ahead and get started. So thank you again to everyone for joining. This is our third one in our series of Title Tuesday. So welcome, Rita, and you guys take it away.
Wonderful. Thank you so much. So can you see my screen, Jody?
Not yet.
Oh, I'm sharing it. Let's see. Hold on. Oh, no, I didn't. Hold on.
And then if anybody has questions or anything, you can put them into the Q&A. And then Rita, you guys can watch that Q&A as it goes and answer any questions, or we can just save all the questions to the end and I'll pop back on once you guys are done.
Okay, sounds good. I think kind of asking questions as they go, only because we're on that topic. So it's kind of helpful if they want to do that.
Okay, then I'll just mute myself and I'll watch for questions. And as they come in, I'll just jump in then.
Perfect. Awesome.
All right.
Thank you so much. Okay, welcome everybody. So today we're going to talk about the preliminary title report and things that you can do to mitigate any issues that might come up, what you need to look for, what you need to understand. So I've got actually a sample prelim here that I'm going to go over, and we'll start through it. And then if you have any questions, like Jody said, just put them in the chat. Okay, so the first one, of course, is just our letterhead showing which branch within the county is processing the transaction. So as most of you know, in Santa Clara County, the seller gets to pick the title company, and often they rely on their trusted realtor to open escrow. So typically whoever has opened, whom you've opened the escrow with, that information is going to show there on that number one area. Number two is going to be whoever opened the escrow with us. So whichever company you represent will be listed there. We have a lovely name there, Daily Planet Real Estate. So just as an example, and then the agent's name would show there under attention where it says Perry White. Number three is going to be our order number. So all title companies have an order number that they like to use. So often when you call in and you have a question, you have your property address, which we can always look it up that way. If you have the escrow number, super handy to have if you have it. For reference, that's when the buyer's name puts it, right, Sherry?
Well, it can be anything. They've actually put in a reference.
Yes. Yes.
We're having a hard time hearing her.
Oh, okay, I'll repeat it. She said often it could be if somebody opens the order online, they can put a reference in there themselves. Also, whenever we get a contract in and we update or amend the prelim, we will often put the buyer's name there under the customer reference. Okay. And then there, just as I mentioned, when we do get a contract, the buyer's names will have to show. The lender requires that as well. So when you first open up the order, again, Santa Clara County, you can open the escrow when it's a listing only. So we're not going to know who the buyer is. But then once you get into contract and you submit the contract, the buyer's names will then be added. Okay, number 6 is going to be the property address of the property. One thing I do always like to point out is that this isn't necessarily the legal address of the property. And what I mean by that is that there are some areas in Santa Clara County where the borders might cross, where it might be in the legal city of San Jose, but like the mailing address might be the city of Campbell. And why that's important is because in San Jose, Palo Alto, and Mountain View, they have city transfer tax. So the client would have to pay that. So oftentimes, sometimes you'll see here where I'm hovering over is Palo Alto. But if you go down to the legal description, which I'm going to show you on the next page real quick, I'm going to skip. See here where the legal description is, right underneath the number 12 there. It says that this property is located in the county of Santa Clara, city of Palo Alto. So 99% of the time, what is on the front of the prelim is going to be correct. But we definitely have areas where San Jose crosses over to Los Gatos crosses over to Campbell, to San Jose. And so sometimes there's a bit of a variance. So just always confirm that or double check it. You can also always call trusted title company. And we could certainly look at the legal description to verify it for you. Okay. Number 7 and number 8, let me move down here a little bit. 7 and 8, I want to go over a little bit. This is a lot of jargon to read. Basically, what number 7 says is that it's a statement to the effect that we're prepared to issue title insurance based upon the information that is in this preliminary report, and subject to the exclusions cited therein and in the standard policy of exceptions. I'll explain that in a moment. And then number 8 says also that no liability is ever intended under a preliminary report, and further indicates what should be requested if the customer desires assumption of liability prior to policy issuance. Okay, so the first one in plain English, number 7, and again, this goes for all title companies. All title companies will have these verbiages on their prelims. Number 7 just states that we're prepared to issue a policy of title insurance based on this report. This report is not a policy of title insurance. It's showing you everything that we're finding on the property and what is subject to coverage. When I say subject to coverage, we're going to go over all these items that are what they called exclusions to coverage. So we're identifying them as we find them. And then number 8, what that means is that no liability is intended under this report. And what that means is, sometimes we get people that call us and say, can you just do a prelim for me on this property? And most title companies, we cannot do that due to the liability. Because if somebody just got a preliminary report from us and maybe went and bought a for sale by owner, right? They use that report. And it turns out that we made a mistake. Maybe we missed a lien that the seller had, or there was an old deed of trust. Maybe there was a building code violation and we missed it. If somebody were to buy a home based on this report, they can't come back and try and make a claim because of this verbiage. This verbiage says that no liability is intended under this report. It's just a preliminary report. It's an offer to issue title insurance. So hopefully that makes sense. Jody, no questions so far?
Nope, no questions so far.
Okay, cool. Did you want to add anything?
Hi,
This is Sheree.
this is Sheree. I'm an escrow officer with Boulder Public Title in Campbell. One quick thing I want to point out, because I think sometimes
You lost her.
Can you hear me?
Yep, there you go.
Okay, thanks. Real quickly, I just want to comment on the buyers' names on a prelim. Many years ago, title companies used to run buyers' information. So, and what that means is we used to run their names on the general index to see if there were any liens against them that might attach to the real property. We don't do that anymore. Title companies haven't done that for a long time. So a lot of times when clients see the buyer's names on the prelim, they're thinking that that means we've run or we're ensuring that there are no unsecured liens that may attach. That's not the case anymore. We're just simply putting on there who the proposed insured is. And lenders get this information confused still. They think that we run the buyer's names, but we do not do that anymore. We're just putting it on there to let people know this is our proposed insured owner.
Okay, thank you, Sheree. All right, I'm going to go ahead and move on to number 9. Number 9 is the date of the preliminary report. So whenever you as an agent will open escrow, the title company will always put the dated date that the prelim was run. So you might open escrow today and we'll issue a preliminary report in the next day or two. Oftentimes it might be several days behind, because usually the data that we have is maybe, up to maybe a week, or it could be a little bit less than that. So why I want you to pay attention to that is because if you get a prelim that's fairly old and you're closing escrow not for 30 or 40 days, we're often going to do an update. One, the lenders require a report that is not less than 60 days old, I believe. But the other thing why it's important is because when we search the property, we're looking for who the owner is, if there's any liens of record. And everything that we find will be up to that date. So as an example, that's March 4th, 2021. So that means that's everything we found up until then. And then what happens is when we go to record, let's say 35 or 40 days later, one of the things that the title company does is runs the property one more time from March 4th to the date we're recording to make sure that no other liens or maybe a bankruptcy or a tax lien or anything popped up to on the property since that report. So, and then if it's an issue, we've got to deal with it before it records. We might, what they call, pull the recording, call us and say, hey, Rita, we found that the seller got an equity line, on March 7th and never told anybody. So now we have to halt what we're doing and get a demand to pay off that equity line before we can close. So I want you to always just be aware of that if I've had one where the seller was in trouble and they were filing bankruptcy at the same time the house was on the market and never shared that with the agent. So they ended up, their bankruptcy recorded, after this date, but nobody knew about it until we were ready to record. So keep your ears open as agents. That's one of the things that we rely on you to, you're our ears and our eyes, and sometimes things are going on that we don't know about that you might be aware of. So anyway, just wanted to point that one out. And then we can move on. We're good, Jody? No questions?
Yep, we're good. I think whenever she speaks, if she could just speak like to the computer, like you are, because the beginning of what she was saying, sorry, was a little choppy.
Got it. Okay,
Yeah.
we'll do that. But I sound okay.
There is a question that just came in. As a buyer's agent, if we see liens, issues for property on title report, what do we do? Who's fixing those issues?
Great question, and we're going to get to that. I've even put a few liens as a sample on this prelim.
Perfect.
Yeah, so we'll get to that, and it should answer that question.
Okay.
Thank you. All right. So number 10, again, this is something that's always on every preliminary report. The title company informs the client what type of policy is going to be issued. Now, there's two policies that get issued for the homeowner. The homeowner gets a policy of title insurance. In addition, if the buyer is getting a loan, there's also a lender's policy of title insurance that gets issued. This one here, the CLTA standard, that is referring to what the homeowner, the new buyer, the new homeowner is going to get. And I wanted to point this out, and I'm going to switch to a flyer here. You guys can see that, Jody?
Yep, we see it.
Okay, so this is a flyer that shows you the two different policies that the title companies issue. One is called a CLTA standard, and the other one is called the homeowner's policy of title insurance. And what it does is it gives you examples of potential claims that could be made and under which policy are they covered. So I know it's probably not easy for you to see the claims, but I'll read a couple to you. Let's see, violation of enforcement of portions of any law or governing regulations. There's an existing violation of a subdivision law. There's a building code violation. Somebody else claims to have an interest in your home. These are all types of claims. If you have the CLTA policy, you'll notice that it covers yes, 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 about the first 4 issues, and the rest is no, 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 no. And then if you go to the homeowner's policy of title insurance, that one covers all of these potential claims that are being issued. So obviously looking at this, the homeowner's policy is the better policy. So I want to point that out to folks because when they look at their prelim, they're going to see on this number 10, it's either going to say we're going to offer a homeowner's policy or a CLTA standard coverage policy. And I know you're all saying, well, why would they issue the CLTA standard policy? Great question. So there's certain conditions that would require us to offer that one. So typically if the property is vacant land, we would issue the CLTA standard. Also, if it's commercial property, most title companies will do the CLTA standard. Also, if you're not a natural person. So this is a classic example. Maybe I know natural person. I hope you're all laughing. That means you're not a corporation or an LLC. A trust is okay. A trust is considered a natural person. But let me give you an example of how this could change. You open escrow on a regular single family home. Prelim says we're going to issue a homeowner's policy. You get into contract with a buyer, and guess what? Your buyer is an LLC. Then we send the contract into our title department to update and amend the prelim. They will now change this from a homeowner's policy to a CLTA standard because your buyer is not a natural person. So I get that most agents don't know much about this, and I don't blame them. It's not really discussed a lot, but it's something to be aware of. In addition, you'll notice it does say that a specific request should be made if another form or additional coverage is desired. There are always instances where maybe you have an investor or someone that's buying it that specifically wants the homeowner's policy. You can always ask or make that request, and we can speak to a title officer to determine if they can qualify for it or not. Sometimes they just want there are certain coverages that they want, and we can almost do like add-ons to say, okay, well, we'll give you this endorsement, we'll give you that endorsement. So it's like added coverage to the policy. So there's things that we can do. So we just always encourage you to ask your escrow officer to then inquire with our title if we need to make an inquiry about that. Okay, number 11, this talks about the type of ownership that you're going to have in the property. Most of the time, you're either going to have a fee parcel there, or it's going to say a condominium. We get this question a lot. If it says fee, under the fee category, it's typically a single family home or a PUD, planned unit development. However, you're never going to see those two words there. If you see fee, it means it's single family or it's a PUD. If it's a condo, it will literally say the word a condominium.
This is Cherie again. I'm just gonna, you probably don't remember this from your practices and principles real estate class. They go into this in detail. Fee simple ownership is, talking about complete ownership. You own the land below and the airspace above. We know this is not the case with condominiums. As Rita said, with a PUD, there's usually common area that is jointly owned, but you still owned the land below and the airspace above on a PUD or townhome. And then it also goes into particulars of how many adjoining walls there are on the property. PUD, townhome, and those terms are not a title term. I know that they are used in the real estate industry, and you guys use these to identify types of property on MLS and so forth. And so we get asked often, can you confirm this is a PUD? And we really can't. It's not a type of ownership that we can confirm. It would just be fee simple or not. So like Rita said, you're either going to see fee, or we will always know it is condo because the ownership type is condo, which is dictated by the CC&Rs that were created for that particular development. Yeah. Do you want to help that? Or?
One of the things that I like to tell agents, sometimes like you're making an offer and you need to know, is this a PUD? Is it a condo? Maybe you don't have the prelim yet. I get calls all the time with agents asking me, can you confirm, is this a PUD? Is this a condo? A lot of times what I can do is just pull prior documents, look at the legal, and a lot of them, and also on deeds of trust, it will have what's called a rider, and it'll say a PUD rider or it's a condo rider. So we have ways of verifying it. So if you're ever in doubt, certainly give your title rep a call, or me personally, I'd love to help. And we can certainly look into that. Okay, no questions, Jody? I can go to number 12.
Somebody's asking if you can cover number 8 again later about when, and you may get to this, when it will actually be insured by the title company.
Sure, when you pay us for a policy. No, it's at the end of escrow, once we close escrow and we're paid. And then at that point, we issue the policy of title insurance to the new buyer that we've insured. that ensures them that they're the rightful owner of the property and that any liens or encumbrances that the seller had prior were all paid off through escrow. So it's at the end of the escrow when it closes. But just having a preliminary report, let's say you got a preliminary report and then you canceled escrow, but you went and used it to go do something else, like I said, pay all cash for something or just for a sale by owner, and something happens where we made a mistake, you can't make a claim on it. But once escrow closes, we're paid for the policy, we issue the policy, then obviously, if somebody were to make a claim, we have to investigate it and we would do our diligence and pay out or do what we need to do to recover it.
Thank you.
You're welcome. Thank you. Okay, number 12, one of my favorites, vesting. It's how somebody holds title to the property. So we always like to tell our agents to look at your vesting and make sure that the person that's showing up on your vesting is the person that signed your listing agreement. We have had many a time, I'm sure Cherie has stories too, where somebody has died and maybe you go to the listing and the wife says, oh, my husband's been gone for 10 years, I'm ready to sell. But the prelim comes out and of course the husband's name is still on there with her because, she never did anything to the property to warrant taking it off. And then we don't know. So we have been, usually when the contract comes in, we might notice one signature. Remember, we often don't get your listing agreements. Don't see that. Sometimes we do. But, we've had it where we call and say, when is Mr. So-and-so coming in? And they're like, oh, he died. Or, oh, he's not available, but we have a power of attorney at the last minute. So please, one of the things if I can impart anything on you, it would be this. If anything is perhaps wrong with your seller, if they are incapacitated, they're not able to sign, you have a power of attorney, those are all things that we can deal with. We just need to know ahead of time so that we can address it. So I'd like to point that out. In this case, we've got Clark Kent, who's a trustee of his trust, Ansel Clark Kent, and he has a 1/2 undivided interest. And then Jimmy Olson, a single man who has a 1/2 interest, and they are tenants in common. So vesting is super important because it indicates to us if anything were to happen to one of these people, we know how to handle the death, right? There's affidavits, death of joint tenant. If there's a trust, we ask for a copy of the trust if somebody has passed. So that's what we're looking at when we look at this vesting. And just to give you an example, let's say in this particular case, Jimmy Olson died, right? Well, in this case, Jimmy Olson, because he's not in a trust and he's not married to anybody, his portion has to be probated. So if you took this listing and you told us Jimmy had died, I've had agents that do this. They just put it on the MLS, they're ready to close, and we're like, you can't do that. We have to probate it. And then we have to get the orders from the court. It's an order of sale from the court, but those can take 40 days sometimes to get. Now, let me give you an example. If Clark Kent was deceased, right, that's different because he was in a trust and we would ask you for a copy of the trust. We would determine who the successor trustee is of the trust. And then when we would determine that would be the person that could sign. And you don't need a court order or any verification other than a copy of the trust. So again, just be alert when you take a listing. If somebody is incapacitated, you think they want to use the power of attorney or somebody's deceased, just call your escrow officer and let them know the information so that they're aware of it when the prelim comes out. They can make the necessary requests for documentation. And then you have a comment about the checking account, right?
Yeah.
Okay, I'm going to put Sherry on. Hang on.
So I have a couple comments just about trust. So when we have title held in a trust, it's really important that you guys know that we can only issue proceeds to the trust. We cannot issue proceeds to the trustees as individuals. The trust does act like a separate entity. And even if the trustees are alive and well, we cannot disperse proceeds to those individuals. And we run into this a lot. This is a pretty common issue with selling real property held in trust because most people who have a living trust, there's no need for them to have a big account set up in their trust. I mean, you're not filing taxes, you're not doing any type of financial transactions under the trust if you're alive. This is just for your security and protection. But it does come up a lot when they're signing off on closing papers. We find out, oh, they don't have a bank account set up in the trust, you know, and some people aren't too happy to find that out last minute. We have a great flyer that we can actually send out if anybody's interested. That is something you could put in a listing packet, or you can just keep handy and hand to sellers as soon as you get your prelim and see that they're in a trust that explains how we distribute those proceeds. I do also want to just remind people when and when we don't need copies of a trust agreement. We get asked a lot, or sometimes if property's held in trust, you know, the agent will send us a copy of their trust agreement, which, you know, is wonderful to be proactive and have that information. We don't need it unless someone has passed away. So if, for instance, Clark Kent, he's the trustee of his trust. Clark is alive and well. He's going to be signing everything. We don't want to see his trust. We don't need to review it. We're not attorneys. We really don't like to have that in our file. The only time we require it is if someone has passed away. Even if one of the trustees has passed away and there's still a surviving trustee, we still want to see it. We have to verify who takes authority after someone has passed under the trust. And we do not distribute trust proceeds either. We get that question asked sometimes, if we can disperse trust funds to beneficiaries if mom and dad are gone. We cannot do that. It has to go to a trust account. Other thing I wanted to talk about on vesting is when you have multiple owners, or sometimes you have a co-signer or a silent partner. This does come up. I had a transaction not too long ago where dad was still on title. He was just a co-signer when, you know, daughter and son-in-law bought their first home, and, you know, he just never came off of the title. So the other thing about vesting is when you look at that, vested owners correlates directly to who's getting proceeds. So if you have 3 people on title and 2 of them have been living in the house and they're going to get proceeds, and maybe this third person was just a co-signer or a partner and they're not going to be getting any proceeds, and really we should not have them on title. We will prepare the deed to have them come off and get that recorded, and they should not be signing anything as a seller, because technically they are not a seller, and we do need to get them removed before the transaction comes to close.
Okay, and I'm back.
Several questions came in on that point.
What a surprise. No, just
I know.
kidding.
We actually just went through this as a family with making sure the title was correct, and they wouldn't even do anything, and we had to go through all kinds of hoops. So the first question I have is, I've seen a prelim in a seller's disclosure, and line 12 is a trust, and I don't know what this means, but SPQ is signed by seller as an individual instead of a trust. Will there be a problem, or is this commonly practiced?
She means on the, I'm sorry, on the real estate document they signed as an individual?
I'm assuming so, whatever an SPQ is.
I don't know what SPQ is. Well, I'll just say from our perspective, when they sign everything with us, they will sign as a trustee. So I might refer you to your broker to maybe see if they have a problem with it. But if they're vested as their name as trustee of the blah, blah, blah trust, they will be signing everything as the trustee.
So they're probably, yeah, signing it as seller property questionnaire is what that is. Thank you.
Got you.
So it's probably that. And I'm assuming if they signed as an individual, they're probably an executor or some kind of something like that that has the right to sign as a trustee.
Or they just didn't put trustee after their name. I mean, I think, haven't we seen on like listing agreement, Sheree, or where they put the name of the trust at the top, like who is the seller, and they'll say Clark Kent, trustee of the Clark Kent Trust, and then Clark Kent signs everything. So again, I would defer probably to the broker.
Yeah, I know that CAR has a representative capacity signature that you guys can use, and some people use. As an escrow officer, that's not something that I'm concerned about. That does not affect my escrow transaction. I would caution you when, if you have buyers who have loans. I had one not too long ago. It was a trust situation. Mom and dad had passed, and brother and sister were both co-successor trustees. Well, they only had daughter. The brother was a little estranged, and the daughter was the one kind of handling everything. She had signed all of the listing paperwork, disclosures, and the contract. Well, when we were, getting our clear to close with the lender came back and said, well, we've got 2 successor trustees. We need that other trustee to go back and sign all of the real estate disclosures. So again, for escrow, that doesn't bother us. It's not a deal breaker. It's not going to hold up your escrow transaction, but I would be cautious of the lenders. If you want to make sure that all the authoritative signers are actually signing. Now, do they care about how they're signing, in what capacity? I don't think so. I just think that they have to make sure that all the actual bona fide sellers are signing.
Got it.
Another question on that, Jody, or keep going?
See, Jen says there's another form for the transaction side that defines the trust. So those are different documents and file for that. If funds are paid into a trust, then how do individuals get the funds out?
Well, so if somebody has, let's just say Clark Kent as trustee of the Clark Kent. So when he signs off, he should have already a bank account with the name of the trust on it, so
Right.
that he can then draw those funds. And let's say it's somebody that died. Let's say Clark Kent died. How sad. He's so handsome. I wanted to meet him, but he died, and now let's say his son is the successor trustee. So let's say his name's John. So John Kent has to have a bank account with the Clark Kent trust. And that's very common. He would go into the bank and say, my dad passed away. Here's the death certificate. Here's a copy of the trust. I'm the successor trustee. And a lot of times the banks will then just update the bank account to show he is the successor trustee of the Clark Kent trust. And so that's where then the money would still go. And then from there, John Kent would then use those funds to disperse the trust. So that's when you say, how does an individual access it? It should be the successor trustee that manages the trust. That's the whole point of the trust. Or the current acting, sorry, yeah, I'm just in the case of somebody that died, or the person that's alive and they're the trustee. They're the ones that have the authority to sign on behalf of the trust. That's how they would pay out individuals. So I think that's what that person's asking, is how does ultimately the beneficiary maybe get the money, is what I'm thinking.
That's my guess.
Yeah, so the successor trustee or the acting trustee is the one that would disperse to the beneficiaries, which that would only happen upon the death, right? So,
and it also looks like money can't be transferred into an account unless it's a joint account with everybody's name on that account that is, it sounds like, in the transaction.
let me have Shirley talk.
You bring up a really good point there, and let me talk on this for a minute. So yes, we have to disperse proceeds to the vested owners, depending on their relationship to one another and how they hold title together. So if you, another common, fairly common, is that we'll have a husband and wife on title and they don't have a joint bank account. Technically, we are supposed to only send those proceeds to a joint bank account if you are married. Now, I don't mind if we split them to each account, but it has to be 50-50. And that is because we're in a community property state that they're very strict about spousal interests and proceeds. If you have unrelated people or brother and sister or cousins, whoever, but they're not married, then we can disperse to those individual accounts based on their ownership percentages. So if it's 50-50, they split the proceeds. If it's 70-30, then the proceeds have to be distributed that way to those individuals.
Thank you. There are some more questions in here, but I don't know how many pages is this, so I want to make sure we get through all of it.
Okay.
At least within our time. If we need to go over, if you guys are okay with that and everybody wants to stay on, we can. So I'll let you keep going and we'll do more questions in a little bit.
I think that's perfect. I totally agree. And well, I'm happy to stay on, so it's not a problem. Okay, so the next one, number 13, is the legal description, which I sort of just touched on earlier. It references the property, the county that it's located, the city that it's in, the state that it's in. And then you'll notice it has the APN, which is the assessor parcel number. That's how the assessor identifies the property. So you will always see that any document that records a deed of trust, a grant deed, it's always going to have a legal description. And so it's always on the prelim as well, but it's also what gets attached to the documents when they record. Okay, I'm going to move on then to what they call now the exceptions coverage. You'll even see it says this, as of the date hereof, exceptions to coverage, blah, 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 would be as follows. So this is everything that's excluded from coverage. And what that means is that we're showing the potential buyer and the lender everything that we have found on this property. So if there was something on here that maybe a buyer objected to or didn't like, that's something that they could have awareness of now and deal with it. Maybe as an example would be a building code violation. Now, obviously we can't close the escrow if there's a building code violation. We need to reach out to the sellers. Maybe they've got, sometimes a shed or an add-on or something that wasn't approved by the city. And so they either have to remove the structure or whatever the city says to do. But sometimes maybe there's something else that maybe there's an easement where somebody has a right of way to your property and a buyer's like, I don't really like that. Well, there's really nothing you can do about it. The easement's on here, we're showing it to you. Let's say you went ahead and closed escrow and then suddenly you find out that there's this easement where somebody's, using a road or an access way through your property to get theirs, and you have a problem with it and you want to make a claim. This is where we can say, no, Mr. Buyer, we showed that on the prelim as an exception to coverage. We made you aware of it. So I'm just trying to give you an example of what that means. Is what we're showing you here is everything that's secured property, and therefore nothing that you could make a claim on or say you didn't know. It's because we're making you aware of it. Okay, so I'm moving on now to examples of what are different things. So some of the things you might see are easements that are on the property. So the first one here, number 15, is a public service easement. So it often gives public utility companies the right to come to your property to measure meters or things like that. There's also the next one for a wire clearance easement. Then we have the building setback line. And that one says that you can't build from a certain portion of the property. I just want to make sure everybody knows this, that not all restrictions, building restrictions, are shown on the pre. If there is one that is recorded, we will show it. But if you have, which we're seeing a lot now, a lot of buyers or investors want to, tear down and rebuild these homes, you want to make sure that you have them check with the city because there's a lot of restrictions that may not be showing on the prelim. But if you see something like this, I'll give you an example. I had one, this was a true story. I had an agent that called me, escrow had already closed. And she said, my buyer wanted to build this like outdoor kitchen in the back, wanted to have like gas whole setup in the back, right? And he went to the city for filing like the permits or to get the permits. And they told him, you can't put that kitchen there. You have an easement, a setback line for an easement. And she's like, well, what do we do? And I said, well, was it on the prelim? And it was on the prelim. So meaning that there's really not much you can do. It was disclosed to the buyer. And so my point in saying this to you is, as a realtor, if you've got a buyer who perhaps is going to be doing some work or wants to make some additions, do some changes, it would behoove you to encourage them to go to the city to see what the real restrictions are. You can't just rely on what happens to be one recorded easement on your prelim. And we're seeing that a lot right now, where people are doing lots of remodeling and additions and things like that. Okay, so CC&Rs, this is a little bit easier to understand it this way. CC&Rs, which are covenants, conditions, and restrictions, they're necessary in orderly development of land to maintain uniform standards of development. They are created by the developer at the time of development. They are often required as a condition of approval by the city or the county, and they are enforceable only through an action in court brought by other property owners within the same subdivision. And then any prejudicial restrictions, usually old, contained in CC&Rs, are unenforceable by operation of law. So there are some really old CC&Rs that say restrictions about ethnicity or race or things like that, really, really old ones. And they are recorded. And if you see that on there, they're obviously unenforceable. We have had people, asked to have them removed or taken off. And as one of my wonderful title officers once said, it's history. And sort of, you can't really remove history unless you want to go file an action and get it removed. But obviously they're unenforceable. And just because someone is in a single family or a single family home doesn't mean they don't have CC&Rs. I think a lot of newer agents sometimes confuse CC&Rs with homeowners associations. So CC&Rs are independent of that. So you can live in a regular tract home and have CC&Rs. They might say you can't raise livestock, you can't paint your house a certain color or things like that. So CC&Rs you will probably see on a lot of prelims. There are some homes that don't have CC&Rs. It's not overly common, but I've had agents go, hey, I think you guys missed the CC&Rs. And then when I call title, they say, oh no, this property doesn't have any. So that does happen. But if this is an HOA situation, you will not only have CC&Rs, you will have reference to the fact that it's part of a homeowners association and that you need to defer to the homeowner association in terms of what the dues are. So when you have a listing that is has a homeowner association, maybe it's a condominium, what happens usually when you open the escrow is that you will ask us, or we'll ask you, would you like us to find out who the HOA is and what the charge is for the HOA documents? So HOA documents have a lot besides CC&Rs they include, but there are budget, there are bylaws, there are guidelines, there's minutes, newsletters. They also give us a demand that says that this current owner of this property is current on their monthly payments. And, oh, what's the owner occupancy ratio? A lot of times lenders will want that. So we order a package on your behalf. Most of the time they charge, oh gosh, $450 now, anywhere from $300 to $500 up front they want for us to order the package. And so we will do it on your behalf. And typically, the way things are selling so quickly, most agents are asking us to order them right away. By law, they have 7 to 10 days to get them to us. And sometimes if you want to rush, you can, but they'll charge you like $100 for a rush. We've seen it and we do it because sometimes you're having a quick close. So be aware of that if you're a listing agent and maybe, on the contingency for HOA, it might say 3 days and you haven't ordered yet. We're going to have to scramble to try and get them that quickly. Anything you want to touch on for those?
Maybe just real quickly, I mean, the easements in this example here are very standard. Public service, wire clearance, that's probably if there's a telephone pole. And, these aren't anything to really be worried about. As I will explain to buyers in assigning, is that all this means if you've got a telephone pole in your backyard or the wire there, that in case of an emergency, that utility is allowed to come and access that utility without the homeowner's permission to do so. Now, PG&E and Public Works, water companies are really good about giving people notice before entering property if they know, but this protects them in case of an emergency. They do not need homeowners' permission to access that utility. Building and setback lines are pretty standard, and that, as Rita said, that's just a setback line that's from the street. to the front of the house. You cannot build in a setback line, and those usually range anywhere from 10 to 40 feet. And then the CCNRs, you know, these are hyperlinked in our prelim if you get the PDF copy emailed out. And I really do encourage interested buyers to read the CCNRs, whether or not they're applicable anymore. I mean, sometimes that, you know, there is information about if they're planning on putting a 2-story on that home. Maybe in this neighborhood, they're not allowed to be a second story, you know, or if somebody wants chickens and it says in there that they can't have livestock. So I do encourage people to read CCNRs and then let them know that, hey, if you have any questions about current restrictions, please talk to the city. But they are good for people to understand what the restrictions are on that property when it was built.
There is an HOA question I'll ask real quick. Who, in your experience, pays for those HOA disclosures?
The seller is required.
Okay. And then I will let everybody know, and I'll put a link in the chat box. We had Jackie Berry on about a month ago talking about HOA docs, and she went over everything. We may have her back, or if there's somebody else that can also go over HOA docs, just, you know, for all of these things as we go through.
Okay. All right. I'm going to move through now to the deeds of trust. Let's see. Okay. So I've got 2 here I wanted to show you. So typically your seller is going to have a loan on their property. I mean, sometimes it's free and clear, but oftentimes they have loans. So you'll see the first one. It's a regular loan, $162,000. The beneficiary is Happy Investment Company. So typically when somebody has a loan on the property, we'll order what's called a payoff demand. So we'll reach out to Happy Investment Company and say that Mr. Clark Kent is selling his home. We intend to pay this loan off. Please issue us a payoff demand. So all the title companies have to do that. We have to get a demand directly from the lender, giving us the number that's required in order to pay this loan off. We can't take just a statement from the seller or anything like that. Now, I wanted to show you on the second one, we have a funny, Dudley Moore. Depending on how old everybody is on this, I hope everybody knows who Dudley Moore is. I'm showing my age. Dudley Moore and Cindy Moore are the beneficiaries. So they lent Clark Kent money. Now, we have that a lot where people maybe borrow money from a private beneficiary. Maybe they borrow from their parents. So it's not a problem when they do that. We would then we would ask you if we could reach out to the seller to say, you know, do you know Dudley Moore and Cindy Moore's email, phone number, how we can reach them? Because we have to order a payoff demand from the private beneficiary. Normally, this isn't a problem. It only becomes a problem when somebody that is a beneficiary is no longer with us. So if they are deceased, it can be a real problem. So one of the things we just love to do when we get our prelims, I know Cherie is very good at this, and most of the escrow officers I know for Old Republic Title, they review their prelims and they will reach out to you and say, we received the prelim, we've reviewed it. It looks like there's 2 loans on the property. Please confirm that with your seller. And then a lot of times we get an email back saying, oh, you know what? They said they only have 1 loan. They don't know what your other loan is. Or they'll say, oh, they said they paid that off a long time ago. Well, one of the problems that we get with private beneficiaries is even if they're paid off, people don't know how to record the reconveyance. And why would they, right? They're the consumer. They don't know what needs to be done. So usually with a title company, we help facilitate that, make sure that the reconveyance gets recorded. But a lot of times people might say it's paid. We want to see proof that it was paid, maybe a statement from the beneficiary, or what would we do, Cherie, if they died? We would then need like if both of them died. So if one of them died, let's say Cindy is still alive, because their beneficial interest, I'm showing right here, was joint tenants, it's okay because joint tenants means right of survivorship. And so we would then take the statement from Cindy Moore. If they both have died, and this loan is still showing, we would then need to find their, who would it be, their inherit, who, Their heirs, excuse me, I couldn't come up with the word. So we would have to find out who their heirs are so that we could reach them to sign the documentation to pay off the loan or give us a zero demand that nothing is owed, and then also to sign a reconveyance, because we want to clear that up. We need to before we give clear title to the buyer. So we need to record a document that removes this from the property. So my point in telling you this is not to scare you. It's just that we want to know ahead of time. And so if you as agents are reviewing your prelims, you know, it's a great conversation to go over with your seller. And that's what I'm hopeful here, is that you guys feel a little bit more comfortable with your prelims so that when you talk to your sellers, it's something that you can mention and go over. Any questions on that, Jody?
There's one about when a seller wants to sell their property, but still has a loan on the property. Is it the same and easy as a paid off property? So if there's still a
Absolutely.
loan? Okay.
Yeah, because it's very quickly, like, especially if they're institutional ones like Wells Fargo, Chase, or Bank of America, they're very quick. Within a couple of days, we can get a payoff. And some of them require a social security number. But again, our escrow officers will reach out and say, I think there's a seller's form that we send them, I believe in a welcoming package where we ask them for that information. And then once we have it, when you get in contract and we know, we kind of schedule it so that if it's going to close on a certain date, we order the payoff maybe a week before the close so that it's ready to go when the seller signs off all their escrow papers and their net sheet. So yeah, I mean, it's certainly easier when it's free and clear, but it's not a problem. It's only a problem where when we have an old deed of trust. I actually have one recently where it was a credit line from 1980 something for $15,000. And it was a credit union, excuse me. And the credit union no longer exists. We had to call like several different credit unions to say, hey, did you take this one over? It was kind of a bit of a nightmare. And in those cases, there's things that you can do. We can ask for documentation that shows we can do a lost note bond sometimes. It's a little bit more work, it can be done. So every situation is different, but for the most part, regular loan, not an issue. It's very, very easy.
Awesome.
Okay, so I'm going to move. Remember back, somebody asked me about what type of liens there might be, I think early on.
Mm-hmm.
I'm going to skip a little bit and just go right here. So you have to understand, when somebody opens escrow with us, they give us a name. Okay, let's use Clark Kent, okay? That's probably a kind of common name, right? Kent might be a common last name. And Cherie alluded to that a little bit earlier, that when you open escrow with us, she was talking about running a buyer's name. We're always running the seller's name, which means that we run it to make sure that they don't have any liens or judgments. And so let me give you an example. Like my last name is Allam, A-L-A-M. There's not a lot of Rita Allams in Santa Clara County. So if a lien pops up with a Rita Allam, it's probably going to be me. But let's say you have a seller whose name is John Smith or Jesus Gonzalez or Tran Nguyen, or what, was another one, Nguyen, Johnson, any of those common last names for different groups. There's a lot of those people. So in this case, I had them put just some old liens on here. And what happens is when they run the seller's name, liens will come up. There'll be a tax lien. There will be an abstract of judgment. Here's one here. There's another abstract of judgment. Sometimes there's an agreement to reimburse. There's all kinds of liens. And so when that happens with somebody with a very common name, you will see on your prelim this verbiage, which I'm going to come back up. See this number 10? Oh, sorry, number 19 here. And it's saying that we need a statement of information because there are too many possible liens, decrees, matters, which aren't specifically described in the land. Like it may not have the property address on it. It'll just say, you know, John Smith, agreement to reimburse. So we ask for a statement of information. And I think I have one here. Let me see. So this is what a statement of information looks like. And I know it looks like, oh my God, we're asking for blood type and all these other things, but it helps us, right? Because it asks, you know, where do you live? What's your date of birth? Some of these liens have social security numbers on them. Some of them have a date of birth. Some will be maybe a business lien. So if they put their occupation and it has a business name, it helps us. It'll ask for prior marriages and the kids, because sometimes there's child support liens. So if you ever see on your prelim that they are asking for a statement of information, which is this verbiage right here, it's important. We're not asking for it just for fun and to make your life miserable. It's really because we need it. Because title probably has a staff of 10 to 15 liens if they say, we don't know if it's our party. So once you complete it, or you have your seller complete it and they get it back to us, we give it to our title department, who then compares it with all the liens. They'll go through and see, okay, this is not our party, this is not our party. Oh, this one, the social security numbers match. This is our party. And if that's the case, I think what the person asks is, what do? We have to then reach out to the creditor and see, is this loan or is this lien still outstanding? What's required to pay it off? And we get a demand for payment. And we have to pay it off prior to the close of escrow, otherwise we can't issue clear title. I'll give you an example. This is sort of a funny, not so funny one, but we had one where the seller, we had a child support lien that came up against the seller. We had his social security number. We told the agent, it wasn't in contract yet, but we told the agent, your seller has a child support lien. He's like, that's crazy. I've been to their house. They don't have children. So he reached out to the husband, and it turned out that he had a child from a prior relationship that the current wife knew nothing about. And what were we going to do, right? We had to deal with it. He ended up going down to the county directly and paying that lien and getting a satisfaction for us so that we could record it. We even recorded it ahead of time so that we could then update the prelim and not deal with it. I don't know if they're still married, but we're not, what's that crazy show? We're not a talk show. We're just going to do the job and get her done. So that's just an example of liens. Do you have comments on that? Very good. I'm going to let Sheree jump in, and maybe there's a question about it. And I know we're on time there. I think we're at the limit, but we're kind of almost done, Jody. So.
Okay, and if you guys can hang on for questions afterwards, we can do those. And then those of you that need to jump off, you can. Otherwise, if you want to stick around for questions, I'm happy to stay on if you guys can.
Yeah, we totally can. Thank you.
Awesome.
Okay, yeah, real quickly, just on the liens, even with the loans, Rita was kind of talking about a private loan situation on there.
As soon as my prelim comes in, I review them right away. I mean, I try and review them like within 24 hours of getting them, because
I know that you guys are taking listings, getting them on market so quick. I mean, right now it seems like I'm barely getting my prelim by the time you guys are in contract. And so,
sometimes our prelim has action items, important action items that we need to address right away for the seller. So I review those. And sometimes when there's like really old stuff on there, I kick them back to title, and title will review it. And a lot of times if they're old and a low amount, title will just take them off for us. It doesn't mean that they're actually going away from the record, but we do assess, insurable risks. So if there's a $10,000 loan with a private Benny from, 20, 30 years ago, and we can see that the property's been insured multiple times, I mean, that is a judgment call where the title company might just say, you know what, we can see it's been insured. We don't see this as a possible risk or a claim. And we call it just insuring over, and we'll remove that item and just, consider it a non-issue. So, I mean, all of these things are reviewed, should be reviewed up front as soon as your escrow officer gets her report. Child support, those don't go away ever. So even if a child support lien pops up and maybe their child's 30 now, doesn't mean that they necessarily owe anything. So don't panic if you see those. Just have a conversation with the client. Is anything owed? They're like, no, it's been paid off a long time ago. We have to order just a satisfaction statement showing that it was paid current, because those do not go away, child support. And then, okay, real quickly, we do have on here, I did want to go over though, we do have a bankruptcy on here. bankruptcy is really important. That's kind of, something that we talk about in our red flags showstopper class. We do need to see what the status on the BK is, which I can access on PACE online, as well as our title officers, to see what the status is. That's another conversation, because that could really be a showstopper on that. But most of the time, these liens, and please use us, escrow. We are the neutral third party. So if you don't feel comfortable having that conversation with your client, ask the escrow officer to call the owners directly and just ask them about that. That's what we're here for. And we can explain these in a very simple way. Matter of fact, get what information we need and get them addressed. Okay, so I'm going to shoot down real quick just to solar, because this is so common and popular now, especially on newer homes. I think it's like almost required on new developments. They have to put in energy efficient. So solar, a lot of people think that, oh, they have solar, that's something that escrow can handle for us right off the bat, like ordering HOA docs. Unfortunately, no. The solar companies won't even talk to us until the owner has contacted that solar company and told them, hey, we're in the process of selling our home. And there's really not much that they do up front, but they do need to notify that the home is being sold. Once you go into contract, then you need to notify them again that now you have a buyer. That buyer needs to reach out to the solar company and apply. And if they are getting a loan, it does affect their DTI. So the lender wants to know, the lender wants to see what the lease agreement terms are. They want, the transfer agreement signed by all parties. So escrow doesn't really get very involved in solar until all of that stuff is done. More towards the end of our transaction, and then we can order the release paperwork that we need for the current owner, and then they'll start preparing the new documents for the new owner to record at a later date. So usually if I see that, I will just kind of point it out and say, hey, have you contacted the solar company yet? Please do so. They need to be notified that the property is being sold, because eventually we will need to order those release documents. Was there anything else you wanted to say? Oh, does anybody have questions on the solar?
I don't see the solar one, and we've done it. It's been a while. Maybe we should do another one, but we've done classes on solar before, and selling a house that has them. And what do you do when there's still money owed on it, or all those types of things? So
we do have a class on those, and we go over all the different types of solar, lease versus owned outright, the different programs through the state, and property taxes, HERO, PACE, and how it affects the lenders. So we do go over all of that too.
awesome.
Actually, that's pretty much it, Jody. The last part is, let's see, you'll notice once the exceptions end, and again, this should be on every prelim with every title company, it'll say informational notes. And that's how you know that that was the last exception. And then this is just information. And oftentimes it's for the lender for the buyer. They want to confirm that it's a single family home. This is often where you might see single family or PUD. They might show it on the notes section. It also tells what what endorsements we're going to issue. And again, this is coverage for the lenders. So we confirm that that's part of their policy. The one that is very, important, but lenders like to see that there really weren't any transfers on the property within the last, I think, is it year or 2 years? 24 months. And I'll give you an example of that. That was a problem. I don't know that this is still the case, but I had one where the person that was selling the property was flipping the property. And while it was getting ready, she went and incorporated herself and then recorded a deed from herself as an individual to her LLC. And then it got into contract right when she put it on the market, got into contract, and the buyer was getting an FHA loan. And for some reason with FHA, they didn't like to see that there was a transfer of title, even though it was the same individual. They could show that the corporation, that she was the authorized signer of the corporation. It delayed the escrow. They wanted to wait, I forgot how many, it was like 60 days or something. It was just really silly. So sometimes that's why, sometimes when you see there's a deed there on your notes, it's just to show the last grant deed that was recorded. And grant deed, for those that are new, is just any change of title. It doesn't have to do with loans on the property. It's if somebody changed title, they'll show it. Oh, and then Cherie would like to talk about this FinCEN compliance, because this is fairly new for everybody, me included.
I don't have all the list, my cheat sheet here with me, but I do want to point out, FinCEN, if you're not familiar with this has been around now for 2 or 3 years. This came out, and it is only a handful of states that is subject to FinCEN reporting. What it has to do is it is federal, and they are monitoring funds for fraud. And so they have picked out certain states and certain counties that are more higher risk. And so anytime we have a real estate transaction, I know it has to be all cash, and and it is for a buyer, not a seller. And it's if your buyer is an entity. So I usually get hit with FinCEN like when I've got a flipper or an investor and they're buying all cash and it's an LLC or an artificial entity. It has to be sales price of $300,000 or more. And they have to basically it's just an application that they have to fill out, but sometimes it throws people for a loop. It's not something that they're real familiar with. And you know, the form, the application, I think is like maybe 2 pages, and they have to give details of, you know, who makes up their LLCs, their names. I'm not sure if it asks for social security numbers or not, but their addresses, places of business. This gets sent to a special department at our company who checks it against a fraud watch list. And then we have to get the clear that, you know, it's okay to close with this buyer. I have never had one or heard of one being flagged and us not being able to close a transaction. But this is just something to keep on your radar, especially in the area that we live. We have a lot of cash buyers, a lot of investors. And also that because of this fraud watch list, sometimes incoming funds on the wire, I have had funds get held by the Federal Reserve if someone's name even matches someone on that fraud list. I can also delay a transaction. Wires coming from overseas, I've had that happen a couple times. So that's another thing to just kind of be cautious of if you're working with a cash buyer or an investor. Kind of give your escrow officer a heads up so that we can be proactive on that, make sure that the transaction is going to go smoothly and close on time. And I think that's it. Did you guys have any questions?
There are several in here, so I'm gonna go ahead and ask those. There's, speaking of overseas buyers, if a homeowner is overseas, how can they sell the house without coming over? Can you transfer title to the new owner without the seller being in the States?
Yes, absolutely. I had a question, you know, someone asked the other day, their buyer is actually getting financing. I think they're here on work visa, you know, so you don't have to have citizenship to purchase here. Anybody can buy property here. The only issue that has come up because of COVID in this last year or so is getting a notary. So we have had remote online notaries have been approved and extended here continuously for us to make sure that people are notarized. That's approved by the recorder's office for the state in order for us to close. But no, I haven't had any issues. a little bit more work, and of course, just that communication up front so that we can ensure we're taking the right steps to make sure we can close on time for people overseas, out of state. I just did a loan for a couple who's in Italy and they're in the Navy, you know. So we can handle any of those situations.
Okay. Oh boy.
Which avoid questions.
No, I was just thinking of what order I like to try to ask them in a thoughtful order. So let's see. Which agent requires or acquires the preliminary title? Was it the buyer's or the seller's agent?
In Santa Clara County, it's a seller pay county. So the seller pays the title and the escrow fees. So in that case, the seller usually gets to pick the title company, but a lot of times they don't know. So they trust their realtor to choose the title company. So essentially it's the listing side that would open escrow and get a prelim. Now in different counties like Alameda County, Contra Costa County, those are what they call buyer pay counties. And in those situations, because the buyer pays the title and the escrow, they could pick the title company. But a lot of times the listing agents up there will open escrow anyway because they want the prelim ahead of time so that if there are problems, they can deal with them. If you wait until you get the contract and you got an all cash buyer in 4 days, but the seller has a tax lien or they have an old deed of trust we have to hunt down, then we're kind of scrambling at the last minute. So in Santa Clara County, listing agent should, and it's best to do it early as soon as you have the listing so we know the prelim is clear, or if there's issues, we can deal with them.
Okay. Here's an example. Jack doesn't want to sell his house. He just wants to transfer it to his friend Amy. Can he just contact the title company and simply transfer it? Or do they need to do something? And I feel like I know the answer, but.
Most title companies, sadly, even though we know how to do it, we can't prepare documents, even prepare documents and charge a fee. You just don't want the liability of it. So sadly, you can't walk in and say, hey, could you prepare this document for me? We don't have like a rate card for that. However, I send people to a couple different places that are independent companies that do documents for people and they help with the recording. Let me think of the names of the one. Okay, you do that one. Do you want us to put it in the chat maybe? Or I don't have, do I have access to the chat?
If you can access the chat for anybody. I know you, I believe you have to send it to the county, right? To record the transfer of title too.
Oh yeah, but these companies will help you do that. So
Perfect. That's
kind of like you pay a fee, but then they orchestrate the whole thing for you. Now, right now, because of COVID, the recorder's office is closed. So I've actually had a couple people do this. There's a box outside. If you go to the website for the recorder's office, Santa Clara County Recorder's Office, they'll have all the information. And they have a box right now out front where you can put your documents in the slot. You can enclose a check. And I even think they say on there that you could put not to exceed a certain amount so that they'll enter the recording figure for you if you need to have something recorded. So all the information is on that website. So here, one of them is called Valley Legal Documents. And that's also their website, valleylegaldocuments.com. They are really good. I have referred a lot. Oh, I didn't spell documents right. Sorry. It's valleylegaldocuments.com.
Okay, I'll put it in.
Thank you. Typing sideways, so it's
That's okay.
They are great. I've had a lot of people go there, agents, also friends of mine that have gone and they've said they've been really efficient and very good. So they will have to pay a fee. But also, I'll be honest with you, what I like about Valley Legal is that they have other things that they offer on the website, like trust documents. They've got other things that they can help you with in regards to real estate. So I think that's a good resource. And then Sheree said, do you remember the name of the other one? No, she doesn't. We'll use that one for now. It's a really good one.
Okay. Let's see, there was a question about easements. Where in the report can you see backyard easements?
Just like what we went over, typically the first and foremost lien is always the property taxes. You'll always see that first. And I think usually after the property taxes is where you start seeing easements, because typically those are older, right? Like they're there when the home was established or, within a few years of that. And then you'll start seeing deeds of trust because those are recorded, later. So usually right after the taxes is where you would want to look for easements. That's typically where they're at.
Okay.
If there are easements on a property, we can always order a color-coded map too.
So if they want to actually see them on the parcel map, just let us know and we can order that and send that to them.
Okay. You said there was a color-coded map?
Yes.
Perfect. What's the difference between a condo and a townhome title?
Condo is a type of ownership.
A condo is a type of ownership, and townhome is usually considered a style of a home. There's no legal, you'll never see on a prelim something is a townhome. So it's typically a style of a home. And a lot of times people say, well, my client's adamant they want a townhome because with condos, you supposedly own only the airspace, but with townhomes, you own the land underneath. You still have an HOA that limits what you can and can't do. It's not like you can build a wine cellar underneath your tiny homes. Like it's just a style of a home. Yeah, so that's the main difference. But you will see the word condo. If something is a condo, it will literally be on the prelim. Remember where you saw the word a fee? It would say a condo, and then it's a condominium. If it's a townhome, it's probably a PUD or it's a condo. Like we can look up the legal and kind of get an idea. Oftentimes on condos, well, not often, every time on condos, the legal description is very long and very lengthy, and it says it's a portion of something else. Usually anything that's a PUD or like a townhome, it's often a lot and tract legal description, which is very short. It says lot number such and such, tract number. So a lot of times we can help you identify that, but you'll just never see townhome on a prelim.
Okay. A couple more here. How will items affect title insurance? What does get taken off the property records and why?
So all those things, just as an example of what we showed you, the property taxes are always a lien on the property. So even as they get paid every year, they're always going to stay there. And then easements will always stay there because they're recorded against the property. It's nothing that's going to change. The things that would come off would be any deeds of trust that the seller had, like those loans that you saw. We have to pay those loans off in order for the buyer to get clear title. So we can't give them a policy of title insurance showing the existing loans that the seller had. So we'll pay those off and they will be removed from their policy. If they had a building code violation that needed to be repaired, if the seller had the tax lien that maybe showed up on the prelim, those would all be gone. So essentially the new buyer would see their names as the owner of the property taxes, any easements, supplemental taxes, their loan with their new lender. And that's about it. I don't think, if there's an HOA or CC&Rs, those will stay on because that's not changing hands. They're still recorded against the property.
Okay. For GTO, if a cash, and this is a two-part, if a cash buyer is a trust, do they still have to fill out the form? They said they had an all-cash buyer taking title with an irrevocable trust. The buyer was asked to fill the GTO form by a title company. We thought the trust is not considered as a company.
I'm gonna let Cherie answer that.
Yeah, so we would have to review that trust agreement. There are irrevocable trusts that are set up to act like entities and are not like your normal living trust agreement. So yeah, I mean, that is possible that did happen and they were subject to FinCEN reporting.
And I will say, just personally, we kind of did this and found out that even though the house is in a trust and you had two trustees, they couldn't legally sell the house. So we had to change title and do all of these things, and that took time. And then, my mom got nervous because the title company wanted the trust. And my mom's like, for what? And I said, because they have to review the entire thing. They don't care about who's getting how much money. You guys don't care about any of that. You just want to make sure there's something written in it so that the house can legally be sold.
Yeah, we're just looking for authority, capacity, who's authorized to sign. That's all we're looking for. Yep.
Let's see, two more questions. Is FIPTA still in effect?
FERPTA.
It's first then, right?
Yeah, FERPTA. So we deal with California withholding. We don't deal with, well, we do deal with federal, but we cannot close an escrow transaction if they do not have a social security number or tax ID number. So it's really, really far and few that we ever really get a true foreign individual or entity that does not have some type of tax reporting. And then yes, it would be subject to the 10% IRS withholding on the sale. But most of the time we're dealing with CalFERPTA, which is the California withholding, which is much more common.
Okay. How do you compare the updated prelim with the original one quickly?
Yes. So actually on the sample one that we had, so if it's at the top, if it just says update, the only thing that should be updated on there really is the plant date of when the records were run, and maybe we've added a lender or buyer name. If it says amend at the top, then that means that the information in the prelim has changed. But if it just says update, it should just be updated information. There shouldn't be anything new on there. An amend would mean that something has changed.
Okay. So we've gotten through all the questions. That was lies. Oh wait, if 10% hold, how does the seller get their money back?
With the IRS.
Go talk to Uncle Sam.
Now, isn't it 13? I
I'm not
think it
even
has
sure.
gone up. We don't deal with it very much, but we also will refer people to their CPA because a lot of times there's tax questions that we can't answer. We just do what we're told to do, but we can't always explain why or does it apply to you or doesn't. So always just bring it to our attention if you have that issue, and then we'll guide you in the right place.
Cool. And then I'm always told when it comes to trusts and all those types of things and how to title a house, it's best to talk to an attorney.
Yes.
To figure that out. So
Yeah.
those are all the questions that we had in the box. A lot of really good information today, and I think we're going to be probably doing another one. There's a question about how to get a sample prelim. Do you guys have samples? Like, can you send me the one that you guys had, and maybe I can send it out to everybody with the recording? That'd be awesome. Okay.
Yeah,
so we'll get that out to you. And I think we'll do this again. Rita and I were talking a little bit about maybe red flags that come up on title reports, and what do you do with that? Who's responsible for it? That child support thing. That could be an interesting situation.
Yeah, we've got a lot of stories, so we try to make it as interesting as possible.
Yeah, and I think stories are a good thing. I think people relate to that, and then can
absolutely.
They're like, oh yeah, I heard that, and can take it from there. So
yeah,
okay.
We have a red flags class, so we'd love to do the next one, or when it's available, we'll be happy to come back. It'd be the Rita and Sheree show. We'll do it.
I love it. I'm in. All right.
Thank you so much.
You're welcome. And we'll get another one scheduled, and we'll see you guys later.
All right. Thank you, Jody. Thank you, everybody.
Bye, everyone.